Welcome to the NFP COVID-19 vaccine webinar. Thank you all for joining us. Our moderator for today is Chase Cannon. He will be answering the questions that you send through the Q&A today as opposed to the chat. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Please note that we are also updating an FAQ document. Today's presentation is being recorded. Within 4 to 6 hours after this call, you'll receive a follow-up email from NFP Learning with links to both the recordings and the slide deck. The recording and the slide deck from this webinar and future COVID-19 updates are being posted to the nfp.com latest insights page under webinars. In the chat box, you will see that we have shared the deck for today's call that you can follow along with. And at this time, I would like to introduce our speakers for today's webinar. Joining us today are Evandro Giganti, Partner for Proskauer, Suzanne Spradley, SVP, CCO, Associate General Counsel for Benefits Compliance for NFP, and Nelly Rose, AVP of Clinical Pharmacy for NFP. At this time, I'll turn it over to Suzanne Spradley. Suzanne, the floor is yours.
Thank you, Leanne. And I wanted to introduce Evandro. Evandro is going to be the main speaker for today. We're fortunate to have him with us. He is a partner with the Labor and Employment Law Department of Proskauer and has extensive experience with discrimination and harassment claims. He co-heads the Employment Litigation Group. He also co-heads their COVID-19 practice, as you can see. He answers issues related to hirings and terminations, and he counsels employers on employee relation issues and other sensitive employment matters. So he's really in a perfect place to advise us on how to handle these employment-based issues. We also have Nelly Rose. Nelly joined NFP back in 2017 as Assistant VP of Clinical Pharmacy supporting NFP RX Solutions. She is a pharmacist and has over 15 years of pharmacy experience, and she will be here to answer some questions for us. You also heard that Chase is on as a moderator, and Chase and I will try to tackle some of the questions that come through Q&A. We anticipate with a large number of participants, we may not get to all of the questions, and so just know that we will be following up, updating our FAQs related to the vaccine. So if we don't get to your question today, we will be following up with all of the questions that come through our Q&A. So with that, Evandro, I'd like to turn it over to you to get started.
Thank you, Suzanne, and thank you everyone for joining us today. It's really my pleasure, and thank you NFP for inviting me to participate in this program. So as Suzanne mentioned, and about a year ago, or almost exactly a year ago, no one would have really thought that one could be a COVID-19 practice group head, but here we are. And as you can imagine, it's been quite a roller coaster of a year, obviously for employers out there having to navigate the really in the trenches of dealing with COVID in the workplace, employees, family members, visitors, contractors, guests coming down with the virus, having symptoms of the virus. In the case of employees having to work from home, and certainly now, more and more discussion around bringing employees, at least previously non-essential employees, back to work in a safe way. And that kind of brings us in large measure to where we are today and kind of what this program is about, which is vaccination programs in the employment context and what employers can and should do, what their options are, and what some solutions are for employers looking to bring their employees back in a safe manner, protecting the safety of all of them and their families, so as to make sure that we try to stem the tide of the virus. And so we're going to hit a couple of high-level points today and then drill down on them. As you can see, the agenda is pretty ambitious. The first topic we'll cover is whether employers can actually mandate that an employee receive a COVID-19 vaccine, and what, if any, exceptions or rules there are associated with such a mandate. Then we're going to talk about sort of other considerations that employers should think about in the context of implementing a vaccine program, mandatory or in that case, perhaps even voluntary. We'll also talk about some state and local laws that have been proposed, and it's important to note that at this point, proposed is a key word here when it comes to the vaccine. And then we'll talk a little bit about different incentives and wellness programs and the like associated with these vaccination programs, and whether and how vaccination programs might be able to fit within that broader construct, and what employers can do perhaps to incentivize employees to get the vaccine. Next slide, please. Sorry, next slide again. So most of this presentation, at least at the outset, is going to be based on pretty recent guidance about a month ago issued by the EEOC, which is the federal agency that regulates employment discrimination and investigates and prosecutes employment discrimination cases at the federal level. The EEOC has long had guidance on the issue of workplace accommodations and even vaccination programs. Much of that guidance sort of came out during the course of earlier health crises, H1N1 being one. But in December of this year, the agency updated its guidance specifically for COVID-19, and in a lot of ways sort of brought their guidance current with respect to either the current landscape as it relates to COVID. The upshot to the question of whether an employer can actually require that an employee take the vaccine is yes. Broadly speaking, yes. But there are some important limitations on that yes, which we're going to discuss in some greater detail. Next slide, please. In terms of the yes is largely qualified by the fact that an employer can mandate the vaccine, but in doing so would have to make reasonable accommodations to individuals who have either known disabilities, for example, disabilities under the ADA, the Federal Americans with Disabilities Act, or any number of state and city laws that could define disability for purposes of employment discrimination purposes. And two, must provide reasonable accommodations for employees' sincerely held religious beliefs. And we'll get into in some detail what each of those exceptions means and how an employer can interpret and apply those exceptions to make sure that its policy, assuming a mandatory program, is compliant. It's also important to note, big picture, that in order to determine whether an employee is entitled to an accommodation, that would be, for example, some type of exception to the mandatory vaccination program, that employers have to engage in a dialogue with that employee, the same way you would in any other situation where an employee requests a reasonable accommodation. You'd have to engage in an interactive dialogue with that employee to determine really what, if any, accommodation might be available and appropriate given the nature of that person's job, the fact that the employer has promulgated some type of mandatory vaccination program, and whatever medical or religious beliefs that individual has that is contradicting or contrasting with their having taken the vaccine. Next slide, please. So let's focus first on disability-related accommodations. So under the law, and this sort of holds true for any workplace accommodation issue, right? The question of whether someone actually has a disability that entitles them to an accommodation. Under the federal law, a disability is defined as a physical or mental impairment that substantially limits one or more major life activities, or someone having a record of such an impairment. Now, that is a pretty high standard, and historically, in the case law and the authorities interpreting it, it's been fairly difficult at the federal level, although in the last 10 years or so gotten a bit easier, for an employee to establish that they have a disability. I think it's important to note here, though, that as a practical matter, oftentimes employers will think of a disability that an employee might have as a physical disability. So in the case of a request to exempt oneself from the vaccination requirement, that physical disability could be some underlying medical condition that makes it impossible or unsafe for them to take the vaccine. You may know that in the context of, for example, the flu vaccine, there typically are a series of or a host of medical conditions that employees are often asked about before they get the vaccine to ensure that they don't have those conditions, because those conditions would actually present a risk factor for them even getting the vaccine itself. So certainly a physical impairment that prevents them from getting the vaccine would be a disability. But also important to remember is so too are mental impairments. Now, there's not a lot of case law in this area when it comes to exceptions to a vaccination program, but there's a lot of authority on what a mental impairment could be from a disability perspective, and that could be anything ranging from impairments that look and sound like stress, anxiety, diagnosed mental health conditions, PTSD, and a host of others that could present a factor that prohibits or contradicts with someone getting the vaccine. You should also know that from a state and local perspective, the state and local laws tend to define disability much more broadly. So in New York, for example, this, substantially limiting a major life activity like working, eating, sleeping, walking, talking, all that stuff, that's not even a requirement. A disability in state and law in New York and city law in New York would actually essentially be a diagnosable condition for which someone is under a course of treatment or hospitalized. But it could even be, as I said, a course of treatment under the care of a physician. And if someone presents with those disabilities, the obligation on the employer may be to provide an accommodation. So here, as I said, an impairment that's a contraindicator to the COVID vaccine might be one. A mental disability like a diagnosed anxiety or disorder that could be exacerbated by having been required to take the vaccine would be another. There are certainly questions around whether allergies or sensitivities to a vaccine might qualify as a disability. Federal courts on that front are divided on whether allergies themselves could be a disability under the ADA. There are certain threshold requirements, including, as I said, the major life activity limitation, that sometimes make it difficult for an employee to prove that an allergy or sensitivity rises to that level. On the state and local level, though, there is case law, particularly again in New York, strongly suggesting that an allergy could actually be a disability. So there's lots of navigate there when it comes to the question of what's a disability that would entitle someone to an accommodation or an exception from the vaccination requirement. Next slide. The other, broadly speaking, exception that employers would need to make is a religious accommodation, meaning that employees who harbor or have sincerely held religious beliefs, and that's the term of art, that conflicts with a vaccination requirement could be entitled to an accommodation. This, of course, kind of raises all sorts of thorny issues about what constitutes a religion under Title VII and under state and local laws. You can imagine most courts will construe religion pretty broadly, and generally, at least the EEOC has advised employers to make an assumption that if an employee presents with a sincerely held religious belief described as such, that should be something an employer should believe and should credit, unless there's some objective basis for questioning that request. That said, the law is pretty clear that employees who, for example, just have some strong opposition to receiving a vaccine, and one can certainly see that that's true now in terms of people having reservations about the safety and efficacy of it, that those might not necessarily rise to the level of a strongly held religious belief. Religion, the case law says, typically concerns the ultimate ideas about life, purpose, and death, whereas on the other hand, things like social, political, or economic philosophies and even personal preferences are not protected. Now, how that all kind of fits into the broader construct of whether someone's entitled to a religious accommodation in the COVID context, remains to be seen. But it's certainly the case, and kind of just to jump to the punchline a little bit, it's certainly the case that because of these requirements in the exceptions built into the exceptions around religious or medical accommodations, lots of employers are erring on the side of not mandating the vaccine, because mandating it would, in effect, require the employer to, obviously recognize these exceptions and therefore kind of have to dig into some of the nuances of whether someone actually is disabled, whether someone actually does have a religious belief versus something that's more, safety, social, economic, or personal. And so those are obviously, as I said, kind of thorny questions that employers tend not to want to get involved in. But nevertheless, let's continue on the next slide. And once it is determined that an employee, in the context of a mandatory vaccination program, presents with a medical condition that contraindicates they're getting the vaccine, or with a religious belief that contradicts they're getting the vaccine, the question becomes, well, what are the accommodations? What can an employer do, or what should an employer consider doing for that individual? Just a few words broadly on the accommodation obligation generally, even outside of the vaccine context. I mean, the rule is, that employers have an obligation to consider an accommodation, not necessarily provide one if it presents an undue hardship to the employer, which we're going to get into. But also, once an accommodation is necessary, the employer need not provide the accommodation that the employee is necessarily asking for, as long as there's another accommodation that would achieve the same result. So there is some discretion and some leeway on the part of the employer to have those discussions. In the particular case of a vaccination program, one could certainly see, of course, the principal or primary accommodation being excluding someone from the vaccination requirement. And whether that involves allowing that person to continue working from home or taking some form of, paid or unpaid leave, those could all be sort of forms of an accommodation. In other words, granting an exception to the requirement. Could also be, for example, allowing that individual to use a mask or other types of PPE while they're in the workplace. Of course, most people should be doing that now anyway. Could be reassigning an employee to a vacant position that doesn't require a vaccination. For example, a position that can be done remotely, a position that's done with no one else around, or at least with very few people around. It could also be an accommodation along the lines of requiring that employee to submit to periodic testing or maintaining a temperature log or the like. And those are all just examples. But the EEOC, in its very recent guidance, does make clear that, listen, if there's no accommodation that's really available here that would allow the person to actually do their job with the accommodation, then the employer should not kind of automatically turn to terminating the employee, but instead should first consider whether that individual can, again, work remotely or have some other type of leave, whether it's statutory or policy-based leave of absence. The ultimate question, of course, that we get from employers all the time is, listen, if all else fails, if there's no accommodation available, can we terminate the employee? And the answer to that question is ultimately, eventually, yes. Does it raise legal issues? Of course, because an employer has to jump through lots of hoops to get to that point and prove, for example, that the individual is not entitled to an accommodation, or the one that they're asking for is too burdensome, or that there just isn't one that would allow them to perform the essential functions of their job. And those are, some pretty significant hoops to jump through, on top of the sort of practical reality that terminating an employee who presents with a religious or a medical accommodation because they couldn't actually get vaccinated and then didn't necessarily have a job, obviously presents some employee morale issues that an employer, I think, would want to think carefully through before taking that step. Next slide. So there are, as I mentioned, a couple of limitations on an employer's duty to accommodate to begin with. So again, we're in the sphere of a employer that has a mandatory vaccination program, and assuming an employer has the obligation to provide an exception, as I said, for someone who has a disability or a religious belief that contradicts with getting the vaccine, there are limitations on an employer's duty to actually even give that accommodation. One exception, would be in the case of a direct threat, meaning that the individual poses such a direct threat to themselves or to others in the workplace that simply can't be eliminated or reduced by a reasonable accommodation. To determine whether someone actually does present that type of direct threat, you would want to consider, for example, what's the duration of the risk here? What are we talking about in terms of an employee's threat level to the other employees he or she works with? What's the nature and severity of the potential harm? What's the likelihood that the harm will occur? What's the imminence of the potential harm? Listen, I think the reality here when it comes to direct threat is that in situations where an employee works, for example, in the healthcare field, where they're dealing with patients who have comorbidities or underlying conditions, in close contact with patients or other healthcare workers. I think in cases where employees are kind of frontline, first responders, things of that nature, I think that an employer would be in a better position to argue that there's a direct threat posed by this person's presence in the workplace, without a vaccine. Obviously, that threat level diminishes as the nature of the employment becomes less and less, of a frontline nature. Particularly since nowadays, some employers, are having their employees go to work even on a limited basis, wearing all the required PPE, answering all the required questionnaires, and even can require testing, right? So in that context, one could imagine it being difficult for, a more office-based employer to really make out that direct threat argument. That's one piece. And next slide, please. The second limit on the duty to accommodate is, let's assume there is a duty to accommodate. Let's assume that there's an accommodation that actually works, right, that would allow the employee to perform their job, or that's available. At the end of the day, any employer is not required to give an accommodation if that accommodation results in some undue hardship on the organization. And that can mean anything from operational difficulties, financial difficulties, and the like. There are different standards for what constitutes an undue hardship under the law, so you'd want to kind of be clear on what you're looking at, whether it's a disability accommodation or religious accommodation. And as I said, like the direct threat, undue hardships can I can imagine in this circumstance be found in again, healthcare roles where there's frequent contact with the public and others who are kind of at a higher risk, in areas where there's a high level of community spread early on in the process of administering the vaccine when many people have not been vaccinated, or where you have essential roles that do not allow for work. One can imagine in those situations that creating some exception for someone to not have to get the vaccine could create an undue hardship for employers or industries in that context. Now, the reality on all of this, okay, is that when an employer decides to make the vaccine mandatory, as I said, there really is a fair amount of kind of requirements that need to be considered when it comes to creating the exceptions to those, including, as I said, the disability and the religious accommodations. And as I said, lots of employers, are kind of, at least in my experience, moving away from a mandatory program towards something more voluntary, simply because they don't want to get into the business of adjudicating someone's medical conditions or religious beliefs and making exceptions or not making exceptions. That's one principle, maybe not only reason why employers are tending not to impose a mandatory program, even though by law, there's a way to do it, and there's a way to do it that in a manner that would be compliant. Next slide, please.
Evandro, before you go, I would like if you could also address, we've really been speaking to, and maybe you want to do it after this slide, but you've been speaking to those that would potentially qualify for an accommodation. If you could also speak to employers who are considering terminating employees who don't meet those, don't fit within the religious exception or any of the exceptions for requiring reasonable accommodations.
Yeah, that's a very good question, Suzanne. And I think what I would say there is, I've had a fair number of clients, with that issue, and have counseled employers through it. At the end of the day, when all else fails, if there's no available accommodation, if the employee can't simply perform the job without having a vaccine, or at least that's the employer's position, even the EEOC kind of implicitly recognizes an employer's ability to let an employee go in that context. The legal analysis is, we don't have an obligation to accommodate this individual because of all these exceptions. And so we could let that person go. The practical reality is that I think it's a tough pill to swallow. I think it's a tough pill to swallow for employees and for employers. Because as a practical matter, you're going to be faced with an employee who has a medical condition or who really does have a sincerely held religious belief, who in the face of a mandatory vaccine program says, listen, I really want to come back to work. I'm dedicated to this company, but I have this condition that just prevents me from getting it. And I think, for an employer to take that step after jumping through those hoops and say, well, listen, sorry, but, we're going to have to let you go, again, is a tough pill to swallow. Of course, the principal question I have for clients in that case is, well, why can't this person work from home? Like, and maybe the answer is they can't, right? But lots of employees can. Or why can't this employee kind of remain on an unpaid, doesn't have to be paid, leave of absence? Why can't we let that person exhaust their paid time off and then go unpaid until such time as it becomes safer for them to return, or until such time that a larger proportion or percentage of the workforce or the public is vaccinated? I mean, those are difficult questions for employers to answer too. But I think there's a real optics issue with terminating someone in that situation. But I will say it's been done. I mean, there are certainly businesses that have taken that approach because the person really is essential and they really can't do the job from home, and the nature of their job really does prevent them from being able to do it without a vaccine and still do it safely. If they're dealing, particularly I'm thinking people dealing with the public or patients, um, things like that. On the issue of EOC guidance, it's also important to just keep in mind that there are very specific rules, and we'll get into this a little bit later too, that govern how an employer or whether an employer can ask an employee medical questions or require that employee to undergo medical examinations. It's a whole universe of regulation and guidance on this particular topic. And the upshot is that an employer generally cannot require a medical examination or make a medical inquiry during the course of an employee's employment unless that inquiry or examination is, quote, job related and consistent with business necessity. That's the restriction. So again, it goes back to an employer's ability to justify those inquiries and examinations. Now, the good thing is that the latest EEOC guidance makes clear that a COVID vaccination itself doesn't actually qualify as a medical examination or an inquiry because it's the administration of a vaccine. It's not a question and it's not an exam. However, the guidance also recognizes that in connection with such vaccination, oftentimes whoever's administering that vaccine does have to ask the recipient some pre-screening questions that could implicate these requirements. In other words, as I mentioned earlier, if you have to ask, or someone has to ask, someone getting the vaccine, do you have this condition or that condition that could prevent you from getting the vaccine? Or are you experiencing these symptoms or those symptoms, fever, headaches, what have you, before you get the vaccine that would, mitigate against getting it, right? Those questions by themselves very well could constitute disability related inquiries because they could elicit information about someone's disability. And in that case, an employer would have to consider whether it is meeting this job related and consistent with business necessity standard. So it goes back to the question of how necessary is this vaccine? And one potential, way out of this is if, for example, an employer required that someone got a vaccine from someone else, like not someone that the employer contracted with or not someone that the employer hired, and certainly not someone at the employer themselves, but a local hospital, a local clinic, a local pharmacy, or what have you. And ultimately, all that was required is that the employee present with some proof that they got the vaccination. That's one way to avoid this consistent with business necessity examination or inquiry. And the guidance from the EOC is equally clear that requiring an employee to show proof that they got a vaccine is not in and of itself a disability related inquiry, as long as the employer doesn't question the person on why they didn't get the vaccine. So if someone comes and says, nope, I didn't get it, the company says, well, why not? That could constitute an inquiry that is generally prohibited unless it's job related and consistent with business necessity. So employers have to be really mindful that, yeah, there is some latitude, certainly to have a vaccination program if that's something they want to do. They can have some latitude to ask employees if they've been vaccinated and provide proof of it, but they need to be careful when it comes to asking questions that could elicit medical information about that individual. It could be something like symptoms, and it could also be underlying medical conditions. So sorry, with that next slide.
And Evandro, before you
Yeah,
move on,
yeah,
I'm just
sure.
going to ask you a couple of questions that came through related to
Sure.
accommodations. For one, you had mentioned that there were some state laws potentially that spoke to disability. There was a question I thought was a good one to address is if there is, you have a state law and a federal law that differ, how do they know which law applies if there is
Yeah.
some type of a conflict or one is more strict than the other?
Yeah, that's a very good question. So, and it happens every day. I mean, when it comes to the federal anti-discrimination laws in any setting, including accommodations, the way you think about it is the federal law kind of sets the foundation, okay, beneath which no state can actually legislate. So that means that states will often implement laws that are at least as protective or more often more protective than what the federal law requires. And so you have to be familiar with the states in which you're located and what the laws are in those states, because what constitutes a disability in New York, for instance, is much broader than what constitutes a disability at the federal level. And an employer sitting in New York would have to comply with whatever the most protective, employee protective provisions are. So in that case, it would default to the state. There are lots of states that don't have very protective laws beyond the federal. There are no states that have laws that are less protective than the federal. So essentially, you have to make sure you know what state you're in and where the laws fit.
And then one other question before you move on is you've mentioned providing an accommodation. Is there any time limit to which an accommodation must be provided?
In terms of how quickly you need to provide it, no, except that obviously you want to provide it as quickly as possible because an employer does have an affirmative obligation to engage in that dialogue with an employee. And so if you kind of drag your feet, I've definitely seen cases and have dealt with situations where employers were accused of kind of taking too long to implement the accommodation or even have the discussion. If the question is how long do you have to keep an accommodation in place, that is, one that kind of is a little bit of a, it's the classic lawyer answer. It depends. An employer is not required to keep an accommodation in place forever. Employers can revisit accommodations. Generally speaking, an accommodation is going to be based on some medical documentation that's provided by the employee's physician to the employer. And usually that will include some description of how long, and certainly should include some description of how long the physician believes the impairment is going to last. And if that physician says forever, right, then there's a concept that an employer doesn't have to, provide an indefinite leave of absence, for example, or even just an accommodation if it's reasonable to revisit this in 6 months or 9 months or what have you. And I think in the COVID situation, it's a very good question, Suzanne, because lots of clients and employers are giving accommodations now in light of COVID. For example, the most common is the work from home, right? Not just because lots of employers have to do it, but even in situations where employers are allowed to bring their employees back to work or they're essential, lots of employers are still letting their folks work from home. That's an accommodation, but it's not one that has to go on forever. An employer can say, listen, this, we're going to revisit this in 6 months, 9 months, what have you. I think there's a reasonableness standard associated with that so that an employer can't say, well, I want to talk about this again in 2 weeks and then 2 more weeks and then 2 more weeks. That seems a little bit unreasonable. But there isn't sort of a set time period that you have to keep an accommodation in place.
All right, thank you.
So next slide. So I mentioned all of the kind of legal nuances around having a mandatory vaccination program versus not having one and what that looks like. But there are a host of other considerations to keep in mind when deciding whether to have a mandatory vaccination program or something not mandatory, for example, strongly encouraged. And these are some of the considerations that we've been speaking to employers about. One, of course, is the employee relations issue. what does it look like or feel like to an employee for their employer to say, you must get vaccinated, okay? Um, you know, it happens in the healthcare setting. It happens with the flu vaccine, I think, in the healthcare setting, and even in the education setting, it happens with, a variety of other, state and local mandated vaccines that educators and whatnot would have to get in order to be in the school. And I get it. But for the rest of the working population, it's not really something that, people are generally accustomed to. And one can certainly imagine and look just in the newspapers, right, to see that there is a tremendous amount of trepidation in the population about getting this vaccine, whether it's because it was approved on an emergency use basis, whether because they have concerns about the efficacy of it or the safety of it, whether you hear stories that people might have had bad reactions or that it doesn't actually protect certain individuals or whatever the case may be. And so to kind of force an employee's hand, right, even with those disability and religious exceptions, right, for people who don't kind of fit within those, it's a pretty significant imposition, one would think, on their personal kind of choices for an employer to make that a requirement. So that's kind of one practical consideration. The second is sort of demonstrating proof of the vaccine. I think by and large, this has been alleviated by virtue of the fact that the law allows an employer to request proof of the vaccine. But even putting that on an employee, may seem to be sort of an imposition. I think states and localities are working through different means of kind of getting people to be able to prove that they took it, either with a vaccination card or some type of app or whatever. But that's another practical consideration. There's also, of course, employee privacy issues. If you had a mandatory vaccination program and you needed to create exceptions, as you do for religious or medical disability, that's going to force employees' hands to come forward with those very private facts, whatever underlying medical conditions they have that you might not have otherwise known about as their employer, or their religious beliefs. And so, again, it goes back to kind of an employee's sense of privacy around that information. There is a whole host of restrictions on privacy from a medical perspective that you would have to respect as an employer. But even apart from that, just kind of the idea that an employee's medical or religious information is floating around in the employer's databases or their HR department, is enough to, I think, make employees and therefore employers a little skittish about a mandatory program. There's also wage and hour issues. This means, what obligations do I have to pay my employees for the time that they are spending getting a vaccine? There is some case law and some authority on this which says that an employer does have an obligation to pay an employee for time spent getting a vaccination while they're on premises during an employee's normal working hours, during the day. And that makes sense, right? But to the extent that employees have to go to clinics or hospitals or other locations, pharmacies and whatnot, to get the vaccine, particularly given the storage requirements that the employers most will not necessarily have the ability to get vaccines on site, do you have to pay people for that time? And that's a bit of an open question. I mean, and it goes back to what I mentioned earlier. You have the federal law, which kind of sets one standard in terms of what it means to kind of, engage in work and what compensable work time looks like. And then you have 50 different state laws that explain their variety and their variation on what constitutes hours worked for purposes of their state wage and hour laws. So it's conceivable that in one state you might have an obligation to pay someone for the time that they spend getting the vaccine, whereas in another location you might not have that. And an employer would have to work through those issues if they were going to administer a mandatory program. I think that kind of issue falls by the wayside when the program is voluntary in nature and not mandated by the employer. There's also a host of liability considerations. What happens if the employee gets sick, or has a bad reaction to the vaccine? What are my liability obligations as an employer? What can I do to mitigate those? Can I get a waiver? Can I get some sort of assumption of risk document signed by the employee? Those are all considerations that do exist. And again, you're talking about state by state. Whether an employer is liable for this would generally turn on things like what your state workers' compensation law looks like, Whether you can provide a liability waiver that might be helpful to an employer depends on whether a state actually recognizes liability waivers in the employment context. I can tell you in New York, generally speaking, there's liability waivers between employers and employees are void as against public policy, so it wouldn't even kind of get off the ground in that case. But so obviously there are lots of considerations there from a liability perspective. Again, I think a lot of that falls by the wayside when an employer is merely encouraging employees to get a vaccine as opposed to mandating it. Also, there are a host of considerations for unionized employees. One can imagine that if you're going to implement or impose a mandatory vaccination program and you have a unionized workforce, that there may be an obligation to bargain with that union over that policy or mandatory policy, depending on the nature of your collective bargaining agreement and your obligations with respect to that workforce. Next slide, please. On top of all of this, because things can never be simple, there are a number of states, a lot of them on the screen now, that have very recently proposed legislation on mandatory vaccination programs. And they kind of run the gamut in terms of what the states are proposing. It's important to know here, at this point in the game, all of this is proposed. There isn't legislation in any state that's been passed and signed by a governor that actually requires an employer to make the vaccine mandatory, or on the other hand, prohibits an employer from making a vaccine mandatory. So you're left with sort of this federal regulation and state and local regulation on the discrimination piece when it comes to accommodations and whatnot. But broadly speaking, some states have proposed legislation that would prohibit an employer from mandating a vaccine. Those are states like Louisiana, Minnesota, South Carolina, Washington, and Wisconsin. And certain other states have kind of more broadly proposed legislation that would prohibit a mandatory vaccination program. In Florida, for instance, the proposed legislation there would actually remove the authority of the state health officer to order vaccination programs upon a declaration of a public health emergency. So there, the statute is, the proposal is looking to remove the state health officer's ability to order a vaccination program if necessary. In New Jersey, the proposed legislation there would say that no person shall be required to be immunized against COVID-19 by some executive order of the governor, by an order issued by any other governmental authority, or by any public or private child care center. In New York, the proposed legislation there says no vaccine could be used for the purpose of inducing immunity against coronavirus. No vaccine, that would be used to induce immunity shall be mandatory, and no person shall be required to receive it. As you can probably imagine, because New York is New York, there's a competing bill which says the exact opposite, and basically says that the law under this proposed legislation would be that the state can mandate that individuals get the vaccine if, according to the health authorities, there isn't a sufficient number of people in the population to achieve what's called herd immunity. So listen, as I said, all of this is proposed at this point, but it's something to keep an eye on because as you operate in different jurisdictions, you may be subject to different statutory requirements. Next slide, please. Just a few words on incentives and wellness programs, and there's a whole, we can get into this, kind of at length, but broadly speaking, lots of employers are thinking, well, okay, like I can't do it mandatorily, but what if I do it, voluntarily, but offer incentives, right? What are my options? There are some options, okay, but I do have to say that incentive options are, in some ways fraught a little bit with risk. And believe it or not, the greater the incentive, the greater the risk. First off, you should know that the CDC has generally and kind of longstandingly proposed certain incentives to increase individuals to get the flu vaccine, including, for example, making it low or no cost, which I think is generally the case, and certainly would be the case with, I believe, COVID. Things like providing refreshments at a clinic or holding a contest for a department with the highest percentage of vaccinated employees. Those are things that the CDC has said in the past might be, incentives to offer individuals to get the flu vaccine. The question is, how does all that kind of translate into COVID-19 and whether those similar, or even other incentives can be provided there? One thing you'll notice about those incentives is they're pretty minimal. They're not exactly, cash in your pocket type incentives. But there are lots of employers who are offering that. My issue with that is if you're going to offer an incentive to get vaccinated, I think you have to navigate the same potential risks that we talked about earlier, which is, by giving an incentive to people who get the vaccine, but not giving it to people who don't, does that mean you're excluding individuals who have disabilities or have sincere or religious beliefs that contradict with getting the vaccine? And in effect, does that raise some type of risk that those individuals can now claim, some type of discrimination because they're being treated differently or worse because of their medical conditions? It's possible, okay? And if an employer decides, well, we're going to do the right thing and offer those individuals the incentive because it's not really their fault that they can't get the vaccine and we want to do right by them, that's laudable. But then that kind of brings you back to the point of where most employers don't want to be, which is having to make those judgment calls between who really has a disability and a religious belief that contradicts getting the vaccine and who just doesn't want to get it because they don't feel that it's safe or they're concerned about it. And so that kind of, in my view, brings you, full circle, gives rise to the same risks. There's also a whole world of wellness programs. And a wellness program is basically, a program that an employer institutes that's intended to improve and promote health among its employees by incentivizing them to, get or stay healthy. Things like incentivizing our folks to get daily health screenings annual health screenings, or promoting people to stop smoking, or gym memberships or yoga or things like that, or for example vaccination programs. The point is to have programs in place that try to get people to get healthy. The rules around these programs are generally that they shouldn't be they have to be voluntary, right? And if you give incentives, particularly significant incentives, then the programs become less and less voluntary, right? Because it becomes less and less likely that someone's going to turn it down if they're going to get, cash in hand or some significant benefit that will really kind of make them, really give them no other choice but to participate in this program. And that kind of creates an issue. So although it's not necessarily relevant today, last week the Trump administration EEOC officials proposed a rule that spoke specifically to the permissible limits of incentivizing people to participate in wellness programs. It wasn't specific to COVID, and it was kind of timed, interestingly, but it was really in response to a series of other court opinions that spoke to this issue. But the rule itself actually didn't even appear yet in the Federal Register where the proposed regulations appeared. It had just been announced by the EEOC. But yesterday, in a sweeping executive order, the new president, as they do every time new presidents get sworn in, basically issued an order halting any proposed regulations that are not emergency regulations, so that the new administration can put its people in place and review those rules. So that rule, I think, is effectively kind of killed for now. May come back in a different form once the Biden administration kind of looks at it more closely. But so there are lots of rules around wellness programs. The incentives are available, but really need to be kind of de minimis so as not to create something that's less than voluntary, particularly if those wellness programs are going to give rise to medical examinations or inquiries like we talked about earlier, which brings you back to the question of whether a COVID vaccine program does, and it could if there are pre-screening questions that are that go along with that program. So next slide. And so finally, we've gotten some questions around whether a vaccination program itself could be something that constitutes a health program or health plan, group health plan under ERISA. The short answer to the question is that an employer-sponsored vaccination program, whether mandatory or voluntary, may well be a group health plan under ERISA. What does that mean? Well, generally speaking, a group health plan under ERISA, just like health plans that we're all used to as employers, would have things like COBRA requirements attached to it, HIPAA obligations when it comes to confidentiality, ACA obligations, reporting and disclosure requirements, including things like filing annual Form 5500s, could also require a summary plan description and plan document obligations and having a formalized claim procedure. So then the question is, really? We need to do all of that when we have a mandatory vaccination program? It's possible, yes. Some things that employers do to potentially address this are make the program part of their existing health plan, but in that case, it would be limited in effect to the employees who are already in the plan. Another option might be to sort of wrap the vaccination program into some broader umbrella plan that could reduce some of the documentation and reporting requirements, but the other requirements would still exist. But really, the most technical requirement to comply with here, and the most difficult one, would be the concept of providing COBRA notice. So really, the upshot here is the last bullet. There are lots of nuances here. There are lots of legal issues here. The question of whether it does constitute an ERISA plan, what the consequences are of doing that, how you navigate those consequences, and what options you might have based on your own company, benefit structure to deal with that are really things that are best left, to consult with your counsel about, your benefits counsel on those issues. So with that, and I think there may be maybe there are questions. I did want to thank you for the opportunity, and happy to answer any questions that the group may have.
Yeah, thank you very much, Evandro. And I'm going to throw a couple of questions at Nelly. I just want to make one point after that last statement concerning ERISA issues. Obviously, we would hope that the department, the DOL, would be flexible as it relates to the pandemic and the vaccines. But we don't know that for certain. We are working with our lobbying groups to see if we can get some clarification around their flexibility with relation to, this group health plan subject as it relates to a vaccine program. And we will continue to update all of our clients on that matter. And but I do want to pose a few questions to Nelly, and then I've got some questions for you as well, Evandro. Nelly, I know you as a pharmacist have been involved in helping provide guidance to our clients and have been really digging into this knee deep. And so if you could tell us, for one, obviously the CDC makes recommendations on vaccine allocations, but ultimately it's up to each state health department. How would an employer find out about the vaccination requirements in their state?
Sure. Thank you, Suzanne. So each state has created their own COVID website. You would reach out to your state's health department in order to pre-register for a COVID vaccine or understand priority groups that are currently in place. I know many states are already in phase 1B and 1C of vaccinations, meaning essential workers, seniors 65 and up, and adults with high-risk conditions are now eligible for vaccinating in several states now. Another way, if you are an employer with employees in multi-states, you can go directly to cdc.gov, and from there it will provide you guidance at the state level, so that way you're able to help direct your employees in different states to the right distribution, and whatever the state governance is for that particular region.
And then Nelly, can you speak to who pays for the vaccine? If you're an employer and you've got a group health plan and your employees are getting vaccinated, who pays for this? And can you give us some insight on that?
So the vaccine itself is covered by the federal government. It's covered by the CARES Act. It's the Coronavirus Aid Relief Act. So there's been $10 billion allocated to cover the actual cost of the vaccine. Now, the actual administration of the vaccinations will be the responsibility of employer groups. And this CMS has provided guidance as far as what the cost would be for administering the COVID vaccine. So, right now, the two vaccines that are available, Pfizer and Moderna, are dispensed in 2-dose allocations, 3 weeks apart. So for those particular vaccines, CMS recommended around $17 admin cost for the first dose and around a $28 admin cost for the second dose. So per utilizer per year would be around $45 for admin costs only. Once more vaccines come to the market that offer a single dose, CMS has advised that the single dose cost will be around $28.
All right, thank you very much. Evandro, I wanted to pose a few other questions to you. We had several questions related to pregnancy and of individuals who are pregnant or trying to get pregnant and whether that equated to a disability requiring an accommodation.
Sure. So again, kind of back to what I mentioned earlier, pregnancy in and of itself is not a disability under the federal law, the Federal Americans with Disabilities Act, unless the individual has pregnancy-related complications that could give rise to a disability. And so things like, related medical conditions when someone is pregnant could certainly qualify depending on, what those conditions are. At the state and local level, the definitions, of course, are broader, and so in most states that I've been advising clients in New York, California, Massachusetts, I think New Jersey as well. Pregnancy might not necessarily constitute a disability per se, depending on the law, but oftentimes, including especially in New York, there are separate obligations to accommodate pregnant employees under the law. So even though it might not be a disability per se, state laws could have, and lots of state laws do have, obligations built in to accommodate pregnant workers. And so, yes, that could certainly translate over into a vaccination exception, accommodation if that's what an employer is planning to do.
Okay, I think we've got time for a few more questions. And again, as a reminder, if we don't get to your question, we will be updating our FAQs and sending those out along with a link to this webinar. But we had an interesting question about going forward. Could an employer make it a condition of employment for a new hire that they show proof of being vaccinated?
Yeah, that's a good question. The answer to that is yes. As I mentioned earlier, the request of an individual that they show that they have been vaccinated is not a medical inquiry under the law, and it's not a medical examination. So it's okay to ask that question. The issue becomes, not asking someone when they say no, well, why not, right? Or at least being able to justify why you would ask why not, given the nature of the job that they have or the nature of the job that they're looking to have, right? Because you'd have to justify that question as being business related and consistent with the needs of the job.
We did have someone ask, what they really wanted to hear, kind of what you are seeing in terms of employers mandating vaccinations. Are you seeing more that are choosing to do it voluntarily? What are you kind of, as a benchmark, what are you seeing? What's your experience been with the employers that you work with? Are you seeing a lot of mandatory vaccine programs?
Yeah, I'd say outside of the healthcare context and outside of, sort of public transportation, first responder type context. So office environments, almost all other environments, most employers that I've spoken with are not going to mandate the vaccine, largely because of all of the considerations that we spoke about today, all the exceptions that have to be made, the imposition that it would create. Most employers are leaning in the direction of making it not mandatory, but strongly encouraging it. And some employers are looking at ways to incentivize employees to get it in the context of a voluntary program. But if you do that, you're going to have to make sure that you're incentivizing employees the right way and not kind of creating risk with the incentives.
And then final question, I've had a few of these come through that asked whether the FDA emergency use authorization for the vaccine can, factors into the idea of making it mandatory.
That's a very good question. So buried in sort of the statute that authorizes the emergency authorization of vaccinations and medications, buried in that is a provision which says that you can't, if you're administering a vaccine or a medication that's authorized only for emergency use, you have to advise the people who are getting the vaccine that they have a right not to take it. And so lots of employers started to think to themselves, well, does that mean that we can't actually make it mandatory? Because built into the emergency use authorization is this concept that they have to be advised that they don't need to take the vaccine if they don't want it. And I think that was a valid concern, but I think by and large, most employers have, kind of taken to heart the guidance of the EEOC, which regulates employers, right? The FDA regulations and statutory provisions don't really regulate employers. They might regulate those who administer the vaccine, like hospitals and pharmacies and whatnot. I think most employers have kind of said, listen, the EEOC says it's okay, subject to these exceptions. And so that's particularly in the context of the COVID vaccine, which is authorized only for emergency use. So I think that's a safe bet at this point.
Terrific. Thank you very much, Evandro, for walking us through all these considerations. Again, we will be updating our FAQs and pull as many questions as we can from those that have been posed on the Q&A. And Nelly, thank you as well for joining. And Leanne, if you'd like to close us out.
Thank you so much, Suzanne. And thank you also to Evandro, Nelly, and Chase for sharing your valuable time and your expertise with us today. For any additional questions that you may have, we encourage you to follow up with your advisor. As a reminder, today's presentation was recorded. Within 4 to 6 hours after this call, you will receive a follow-up email from NFP Learning with links to both the recording and the slide deck. The recording and the slide deck from this webinar and future COVID-19 updates are being posted to the nfp.com latest insights page under webinars. In the chat box, you will see that a link to today's slide deck has been reshared for your convenience. And that concludes our webinar for today. Thank you all so much for joining us, and we hope you have a great day.